Thank you. Be seated. The court is ready to hear oral argument from petitioners in Wilson v. Andrews.
May it please the court, I suppose all attorneys are nervous when they appear before this court for oral argument. I feel a little added pressure today. My co-counsel's son is a student here at Texas Tech Law School, was told by his professor urged to come to oral argument today and was assured that the attorneys arguing the first case were quite good. I'm not sure where that leaves me, but I will do my best. The issue presented today concerns the constitutionality of Texas Local Government Code, Section 143.057. This is the statute that provides police officers and firefighters in civil service cities the options to have their disciplinary appeals heard by independent hearing examiners rather than by the local civil service commission. The issue presented in this case was considered by the Supreme Court just last year in a case, Proctor v. Andrews. In that case, this court upheld the constitutionality of Section 143.057 against the constitutional attacks that were made in that case. In so doing, it reversed a decision by the Amarillo Court of Appeals. Before this court's ruling in Proctor, however, and in fact before this court granted the petition for review in Proctor, the Amarillo Court of Appeals declared Section 143.057 unconstitutional in a second case, the instant case, Andrews v. Wilson. The Amarillo Court in Wilson found that Section 143.057 is unconstitutional for two reasons. First, that it represents an unconstitutional delegation of legislative authority to the American Arbitration Association, the AAA, and the Federal Mediation and Conciliation Service, the FMCS. Secondly, the court found that it constituted an impermissible delegation of the city's police power in violation of Article 11, Section 5 of the Texas Constitution, the Home Rule provision. This court's subsequent decision in Proctor, issued some months later, squarely rejected both bases for the Amarillo Court's decision in Wilson. This court ruled in Proctor that Section 143.057D's use of the terms neutral and qualified in reference to arbitrators did not constitute an impermissible delegation of legislative authority to the AAA and or the FMCS. The court went through the Boll-Weevil analysis and determined it was not an impermissible delegation.
Isn't there another issue at play here, though? And that is that the city ordinance that was adopted by the voters here in Lubbock is different than what was codified under Section 143.
No, Your Honor, that question presupposes something that in fact is not true. The voters of Lubbock in 1947 did not in fact adopt Ordinance 862. They adopted the Civil Service Act,
and
the statute itself.
The scheme that they adopted provided for a trial de novo, did it not?
The scheme that they adopted at that time, the statute provided for hearing of disciplinary appeals by the Civil Service Commission, and then the Commission's decision could be appealed to the court for de novo review, although the standard of review is substantial evidence.
So on the appeal for de novo review, with substantial evidence review, that is a different standard of review than is permitted under Chapter 143, is it not?
Your Honor, there is no doubt, and we do not deny that the appeal hearing procedures as they exist today in Chapter 143 and as they existed under the uncodified statute back in 1983 when the hearing examiner provision was adopted are different from the Civil Service Act as it was adopted by the voters in 1947. There is no doubt, and we do not deny, that the legislature has amended the Civil Service Act many times since Lubbock's voters and the voters of many other cities adopted that statute. The question then becomes, what did the voters adopt? And once they did adopt the statute, can the legislature thereafter amend the statute? And we would contend that the answer to that question is yes. If you look at the procedure for adoption of the Civil Service Act that exists in the statute, the language that exists in the codified version, it was codified in 87, is no different really from the version that existed way back in 1947. You don't adopt an ordinance. The issue that is put to the voters is for or against adoption of the firefighter and police officer civil service law. Chapter 143 and Article 1269 before it apply to cities whose voters have voted, and this is quoting the statute, to adopt this chapter or the law codified by this chapter. This law existed in uncodified form. The hearing examiner provision existed in the uncodified statute after 1983 when it was added by amendment.
Let me ask you where you would draw the lines here. Let's assume that the voters of Lubbock voted to opt into the civil service provision, and let's just assume that it provided for the right to trial de novo, which would allow a right to jury trial as opposed to the type of review that is currently allowed. And then later on, pursuant to the later codification of Chapter 143, it did away with the right to jury trial. Would you consider that to be a substantive enough change from what the voters adopted, such that the voters would have to re-vote on the issue?
No, Your Honor, I would not. And the reason for that is two. Number one, the change that you're talking about, the amendment to add the hearing examiner provision, was not adopted as part of the codification process. It was an amendment to the uncodified statute that occurred years earlier. More importantly, the Civil Service Act itself provides mechanisms. Once a city adopts the civil service statute, that's not the end of it. If the statute thereafter is amended by the legislature in a way that the voters find unpalatable, their option under the statute is to hold a repeal election and to repeal the statute. Another local adoption statute, the Fire and Police Employee Relations Act, a collective bargaining statute, has been both adopted and repealed by cities. I believe the city of Stephenville repealed the Civil Service Act.
Do you know if that has been attempted in Lubbock? Was there an effort made to repeal or get it on the ballot that was unsuccessful?
Your Honor, I'm unaware, and the record does not reflect that there ever was an attempt to repeal the Civil Service statute in the city of Lubbock.
So what you're saying then is that once the voters vote into the civil service framework, the legislature can change it however much they want to, and that the voters only, or the citizens of Lubbock's only remedy is to basically have a recall vote and opt out of it.
Your Honor, that is our position. I do point out that the repeal election option is not an empty promise to the voters that they can get out of civil service if they don't like it. And I do feel that our position has case support in the decisions of this court. In City of Sweetwater v. Guerin, a 1964 Supreme Court case, the court held that the Civil Service Act, that in the Civil Service Act, the Texas legislature had preempted the field of firefighter and police officer discipline. Certainly, if the legislature has preempted in civil service cities the field of firefighter and police officer discipline, they are able to alter those provisions relating to how disciplinary appeals will be conducted.
It is a strange argument that the legislature has preempted the field in police and firefighter discipline, but gives the cities the option whether or not to permit it to be preempted. But it seems to me that's what Sweetwater versus Guerin is talking about, although it says preemption. There's some sort of notion out there that if the city, by its citizens' vote, says we're going to follow what the legislature says about civil service, it's like a legislature will give you permission to preempt our decisions about that. But it seems to me there's very little, in fact, there's no case law that really talks about that. Many of the cases seem to just assume that these amendments have all been valid all these years, even though there's a predicate out there for a citizen vote. Have you found anything anywhere in your research? Or
No.
this precise question has been presented?
Your Honor, this precise question has not been presented, but a decision by this court that a local adoption statute, once adopted by the voters of a municipality, could not thereafter be amended by the legislature as to that city, would apply to all local adoption statutes, not just the Civil Service Act. It would have broad and drastic implications. It would mean that any state legislation that takes the form of a local adoption statute would be different as to each city that adopted that statute, depending on the point in time that they adopted it. It would create havoc. A local
Why
adoption...
wouldn't the legislature, if that was a problem, if the legislature felt it was a problem about declaring certain statutes only applied because citizen votes occurred here, but they didn't apply when they failed to vote, why wouldn't the legislature just preempt the field? Why wouldn't the legislature just say, okay, from here on out, all police and firefighters in this state are subject to state civil service?
The legislature chose to give the cities an option, through their voters, an option of whether or not to vote into this state civil service system. However, once the voters of a city choose to opt in to that system, then they are bound by the Civil Service Act, just as they are bound by any other legislation and subject to its amendments. The legislature, having created the opt-in provision, also created an opt-out provision so that the voters, if dissatisfied with further amendments, could get out of civil service simply by the mechanism of holding a repeal election, as the voters in Stephenville did.
So the Ordinance 862 doesn't really mean anything.
Ordinance 862 was simply the vehicle. A city acts by ordinance. Ordinance 862 was the vehicle by which they implemented the Civil Service Act in 1948 after the voters adopted it. And they have consistently, the city has consistently, there are at least 5 reported decisions, they have consistently applied the Civil Service Act in its current form since that time, and it's disingenuous to contend, as they apparently do in this case, otherwise.
You mentioned that we rejected a home rule cities argument in Proctor, and that's similar to an argument made in this case.
That's correct, Your Honor.
We reserved the issue in Proctor whether there could be an impermissible delegation of authority to hear appeals to a private decision maker. Did the Court of Appeals decide that issue in this case?
The Court of Appeals did not decide that issue in this
It
case, Your Honor.
sounds like it at some point.
I'm sorry?
It sounds like it toward the end of their opinion that they're really deciding something broader than a home rule cities argument.
The challenge that was made by the city was not the delegation to the hearing examiners themselves. Rather, the city challenged the delegation to the AAA and the FMCS. The city made a second challenge, which was that the delegation to the hearing examiners themselves violated not the legislative delegation doctrine, but the home rule provision, Article 11, Section 5. That issue was addressed square, and that issue was the one that was decided in Wilson. Now, they purported to apply the boll-weevil analysis to that.
Why would you do that?
You wouldn't, Your Honor, and as I argued originally in my petition for review, it was a mistake to have applied that analysis. However, subsequently, this court in Proctor looked at the identical Article 11, Section 5 issue, and without utilizing boll-weevil analysis, even though it had previously decided boll-weevil and it was out there to do so, held that this was not an impermissible delegation of governmental powers
But
under Article 11.
if the CA were looking at a delegation issue, the one we reserved in Proctor, they would use a boll-weevil analysis, just as we did.
They would, Your Honor.
Makes it look like they decided that issue.
Your Honor, they did not decide that issue. If you look at the points of error, and I put this as an appendix to my brief, if you look at the points of error raised by the city raised no challenge under Article 3, Section 1 to the delegation to hearing examiners, and the Court of Appeals, although they used boll-weevil analysis, and we contend incorrectly, did not address that issue. They addressed whether this was an impermissible delegation of a home rule city's governmental power under Article 11, Section 5. That issue was decided dispositively by this court in Proctor, and the legislative delegation issue is not before the court in this case.
Thank you.
Any other questions? Thank you, Counsel.
May it please the Court. My name is Christopher Johnson. I'm Assistant Attorney General. I'm here on behalf of the Attorney General. I'm only going to take a moment of your time. The Attorney General believes that it's the position of petitioners has been adequately represented by Mr. Dietz, and all we simply ask is that you, in fact, support the petition and that you do find the provision 143.057 constitutional. We believe that your decision in Proctor is dispositive. We believe that it was correctly decided, and we would ask that you reverse the Court of Appeals. Thank you.
Any questions?
Mr. Johnson, let me ask you, one of the issues that's raised in this case is that the sheriff and the city manager, I guess, have in their official capacity the authority to raise due process and equal protection arguments, and only implicitly was that looked at in the Proctor case. Does the Attorney General have a position on whether or not people in their official capacities have the authority to raise due process and equal protection arguments?
I don't believe that we do have a position on that, Your Honor.
Thank you, counsel. Court is ready to hear argument from respondents.
And please the court, Mr. William J. Wade and Mr. Cecil Coon will present argument for respondents. Mr. Wade will open the first 12 minutes.
May it please this honorable court and Mr. Dietz and Mr. Johnson, on behalf of Mary Andrews, who is the Director of Civil Service and also the Director of Human Resources for the City of Lubbock, and Chief of Police Ken Walker, and the City of Lubbock, we're pleased to present our arguments to the court today. As was mentioned by counsel earlier and by Justice Hecht, on page 735 of the court's opinion in the Proctor case, the court differentiated between the two levels of delegation of authority that are involved in this fact situation. And we agree that the court's opinion in the Proctor case disposed of the delegation of authority to the AAA, or the American Arbitration Association, of the Federal Mediation and Conciliation Service. But the remaining issue was the delegation of authority to the individual hearing examiner, which we say is before the court, and would direct the court's the court's attention to page 691 and 692 of the opinion written by Justice Revis of the Amarillo Court, in which he goes through a boll-weevil analysis, and in fact he comes up with 5 of the factors ruling against or weighing against delegation, and we agree in his result, but we disagree that there ought to be one more, and that's number 6. He should have 6, and it would be the 4th factor that this court mentioned in its opinion, and that is whether or not there is a pecuniary interest or an inherent bias, which leads us into our position before this court. So
that I'll be clear, your position is that the issue that we reserved in Proctor regarding delegation of decision-making is raised in this case and was addressed by the Court of Appeals.
Yes, sir. It's squared before the court using the same analysis that this court used in reaching its decision in the Proctor case, and it's our position.
Mr. Wade,
yes, sir.
Sorry. Now, Mr. Dietz says he knows that's what the Court of Appeals said, but he said you all didn't raise that in the brief, and you didn't argue it to the Court of Appeals. So the question was it a question to bring it before us? It seems to me it has to be a question you brought before the Court of Appeals. Did you do that?
We think it was there in our inherent bias argument before the court, but also I think the court should recognize that the Amarillo Court wrote on it and decided it in our favor. So we didn't have to raise anything. It was Mr. Dietz's issue to raise on appeal. And he took the position on appeal that it disposed of all issues, and we take the position that it did not.
You were not the appellants in the Court of Appeals.
Yes, sir.
You were.
But the court went off, and the court addressed the issue and ruled on it, which, in my experience, has happened to me before on the appellate court. But and so we did get a favorable ruling from the court, and it was not our duty to raise that then further to this court, which Mr. Dietz has, and it's squarely before the court. We think that item number 4 should have been considered by Justice Revis and certainly weighs the balance against delegation. We think if this honorable court applies the same rationale and logic that it did in the Proctor case, then you're going to come out with a different result, but it will be perfectly consistent because we feel that 6 of the factors, including the 5 that Justice Revis came up with and one more, which is number 4, the pecuniary interest, conflict of interest, inherent bias, then there will be 6 total. Now, to
address those, we'd have to first address the standing issue, is that correct?
the standing issue, and we feel that...
Didn't we dispose of that in Proctor? We defined city collectively as including the officials, and why does that not dispose of the standing issue?
Well, I don't, of course, I'll have to defer to the court's memory, but I don't know that they were ever addressed, the individuals were ever addressed.
If the city was defined collectively in the opinion as the individuals, would you agree that it was dispositive of that issue?
That's a good question, Your Honor. I don't know that I could respond to that.
I have a question, and I'm trying to parse all this out in terms of what your arguments are and are not. On your improper delegation issue, you say that it should not have been delegated to these hearing examiners because they have a pecuniary interest, and that violates which provision of the Texas Constitution?
Well, it would violate the Article 3, Section 1. And, of course, we still hold that it violates the police powers, but the court has ruled on that. We'd say Article 3. Now, this inherent bias comes about as the fact that these hearing examiners, they don't get employed. They don't get paid unless some police officer asks to go this route on its appeal.
But how are they performing any legislative function simply because they get paid?
Well, if the court looks at the other factors, you look at, there's no appeal from their judgment. They are supposed to apply the civil service rules. They're supposed to apply the applicable law of the state of Texas. There are no guidelines in the statute binding them in any way, and there's no effective appeal from what they do.
But again, how is that performing a legislative function?
Because they can make their own rules. They have no guidelines from the legislature as to how to apply what to do in these hearings. All they have to be is, quote, qualified and neutral. We don't know if they're from New York, they're from California, whether or not they've ever been a police officer before. There's no guidelines set out in the statute whatsoever, and they're just kind of given free rein to do what they want.
Wasn't that issue more or less foreclosed by our discussion in the first Proctor case?
No, sir, I don't think it was, because we got 2 levels of authority. We've got the authority going to the AAA and the FMCS, but then...
I know that, but I'm talking about on this particular issue, on qualified and neutral. We discussed that in terms of the panels that the 2 organizations could come up with. Why is that then a different standard when it comes down to the individual who finally is selected out of that panel?
Well, I think where it comes from is if the court applies the analysis of the boll-weevil factors to the actual independent hearing examiner, that is where you're going to see that there are no guidelines, there are no standards by which this individual, and I think let me see if I can find it here. Does a private delegate possess special qualifications or training for the task delegated to it? And I think, obviously, the statute doesn't set out anything, and obviously we don't know anything about the qualifications of this individual.
If the qualifications were identical to those that a city hearing examiner has to possess, would that be sufficient? Is that a sufficient test?
Well, obviously, that would be something that would be arrived at as a result of the legislative process and the legislature in their wisdom. It certainly would be better than what we have, because at least to be a civil service commissioner, you have to be a resident of the community and have held no elective offices, et cetera, and be over 25 years of age. As it is now, we have no qualifications at all.
Mr. Webb, let me ask you on the issue of whether or not a form of law that has to be adopted by the citizenry can be amended by the body that creates that law after the vote and still make it applicable within the city. On that issue, Mr. Dietz says that the ordinance, the law that was adopted by the vote, or the question on the ballot that was adopted, was whether or not the city of Lubbock would adopt the civil service law, or something to that effect. And why is it not a reasonable argument that when the voters do that, they are ceding to the legislature the authority to determine what the civil service law is, as opposed to that being some sort of direction of the city council to create its own civil service law?
Well, first of all, we obviously know that the city operates through ordinances and through the city council. If it's our position that if the city wanted to bind itself as to any future amendments, then they should have said in their ordinance, we adopt Article 1269M.
But if your citizens vote for the civil service law, and the statute says that's what you do to adopt the legislature's law, then how does the city have some sort of authority to do something other than that vote?
Okay. It is strictly voluntary. Dallas, Midland, Odessa, Arlington, Grapevine, Victoria, Longview, none of these have a civil service system. There are only 75 cities in the state of Texas that have it. There are a lot of cities out there that don't have it. It's strictly voluntary.
So it has nothing to do with a vote by the citizens?
Right. The citizens express their desire to have a civil service system. The city, through its city council, adopted an ordinance, which Mr. Kuhn will address here in a minute, is not the same. It's close. It's not the same. And they operated under that ordinance for 35 years before this very controversial provision was placed in the 1269M, which was later codified.
Well, let me see how far this goes. It's your position, then, that even though the citizens voted in 1947 to have the civil service law apply in the city of Lubbock, if Lubbock had not passed this ordinance and a police or firefighter had come before the court seeking civil service protection, it would be your position that the vote of the citizens has no effect. We could not say, well, if they voted to adopt civil service, then that would have no impact on our decision as to whether or not that firefighter was protected by the civil service law.
The court brings up a very good point there, and I think our position would be yes, because we enacted an ordinance.
No, I'm saying you didn't enact.
If we didn't enact an ordinance, then we still, the city has to act through the city council. It can't just take a vote of the population and say this is it.
So your view is the police and firefighter, despite the vote of the citizen, would not be protected by civil service?
That's right. He would have the other protections that any other government employee would have.
And why can't it just be taken care of by a simple repeal? Wouldn't that be an easier solution? I mean, the statute's been amended some 30 times since it was originally enacted. Wouldn't it be easier just to let the citizens of Lubbock decide that they want to repeal the whole system as opposed to have to go to the polls every time there's an amendment by the legislature, which would be some 30 elections?
That's a very good point, and that's certainly an option available to them.
Going back to my question about your argument that because the hearing examiners have a pecuniary interest, that there is some constitutional problem. You said Article 3, Section 1. Did you mean Article 1, Section 3, the equal protection laws?
Probably both, Your Honor.
Well, I don't find Article 3, Section
3 is, okay, 3, as I recall, is the legislative function and separation of powers.
On the equal protection argument, it
would be Article 1.
Section 3. I want to ask you about that. Okay. You take the position you have standing to bring the constitutional question of whether it's the delegation or the pecuniary interest is unconstitutional, but that does not necessarily resolve whether the city can say that it individually or the city as an entity is harmed by the equal protection, or if the failure to have equal protection doesn't. I mean, standing's different from the substantive issue.
I agree with that.
And don't you lose, even if you have standing, on the substantive issue because cities are not entitled to equal protection under our Bill of Rights?
Of course, we're faced with this proposition, and surely somebody's got to be able to challenge this.
Who does it harm other than the city? Whose equal protection rights are harmed other than the cities?
Okay, I see the court's point.
Any other questions? Thank you, counsel.
May it please the court. The Section 143 of the Government Code, just as the previous Civil Service Statute 1269N, is something that has to be adopted. And in a city does not, Chapter 143 and Section 143.057 is not in effect in the city of Lubbock unless the city of Lubbock has adopted that by an election in Section 143.002. Wilson takes the position that the city, by its voting on and approving 1269N, therefore is bound by Section 143 because it's a revision or codification. We submit that it's not a revision or codification, but it's an entirely new law, and they can't bootstrap their way by saying that Section 16C was added to 1269N in 1983, which was 15 years after the vote and the ordinance, which had a arbitration provision similar to 143.057.
Let's assume that it was not a recodification, but was a change in the law.
That's correct, Your Honor.
Why wouldn't the answer to the problem be that the voters have the right and the opportunity to vote to opt out of the new law?
They could have, Your Honor, but it's our position they're not under the new law because the new law is not a codification, it's a new law, and they wouldn't be under the new law unless they adopted it. I would like to cite the court to, in support of our position, Article 3, Section 43 of the Texas Constitution specifically talks about substantial, being substantially the same, and this court recently decided a very similar issue in Fleming Foods against Rylander on June 10, 1999, and this court there specifically held that a statute does not constitute a codification or a revision if there is a substantial or substantive change in the prior law, and we submit that this certainly was. The adoption, as Mr. Wade has said, the voters did vote on 1269N, but 6 months subsequent to that, the city council voted in this ordinance. It is not inconsistent with 1269N, but it's totally different from 1269N, whereas 1269M has 2 or 3 pages on this procedure. The ordinance has only two one-sentence paragraphs governing the city council functions in hearing appeals from disciplinary action.
So is one of your positions that 1269M was never effective in the city of Lubbock?
It was probably effective until the city council acted and adopted the ordinance. But we submit that the council had authority to adopt that ordinance on behalf of Lubbock, and once that did, that was a controlling law in the city of Lubbock as far as city civil service is concerned, and the city has been governed by that order. The ordinance specifically says that the only way it can be revoked is by a vote, and there's never been any vote to repeal that ordinance, so it's still in effect. If I would also speak very briefly to this inherent bias issue, it was issue number 3 in the Proctor case. It's our point number 4 in this case. This comes under Article 1, Section 3 of the Texas Constitution. It's a facial challenge to the statute, not an applied challenge. When we say the statute on its face provides an inherent bias because the hearing examiner knows that only the police officer or fireman is the one who can select a hearing examiner to hear this case, so they're naturally going to want to try to do something to satisfy the policeman or fireman, so they will be selected in future cases and get a fee.
Is that an equal protection or due process argument, or is that some other argument? You said Article 1.
This is an equal protection argument, and the Amarillo Court...
Do you agree that municipalities don't have a due process or equal protection right?
That's correct, Your Honor. In the city, the Court of Appeals in this case held that they didn't reach this inherent bias argument either in the Proctor case or in this case because the court held that this was an issue that the city didn't have standing to raise, but the court, we submit neither court has passed on a question of whether or not Ken Walker and Mary Andrews had standing to raise this issue, and they're charged with enforcing this statute, and if it's unconstitutional, we submit under the Durish case and the Coon case and others that they do have standing to raise this issue.
But you are very clear that they are only in this case in their official capacities.
They are what,
They're
Your Honor?
only in this case in their official capacities.
Yes, that's correct. That's correct, Your Honor.
Any other questions? Thank you, counsel.
Thank you.
Mr. Dix, who would have standing to make a due process or equal protection argument?
I'm sorry, Your Honor, I didn't hear you.
Who would you say would have standing to challenge this statute under equal protection or due process basis, if not the city or officials?
The firefighter or the police officer obviously
But
would,
they never would,
of course.
and so it would be incapable of review under your position.
Well, that's correct, Your Honor, and the simple reason that it would be is because the city, as a city, does not possess due process or equal protection rights. And in answer to Justice Enoch's question to the Attorney General, we would contend that Mary Andrews and the police chief in their official capacities are no different from the city in that regard. As defendants' counsel admitted, they are attempting to use that artifice to assert equal protection and due process arguments on behalf of the city. They're asserting rights that the city does not possess.
Well, this really isn't a standing issue, it's a substantive issue. They may have standing to raise it, but they may lose on the substantive ground.
Well, Your Honor, I don't think they have, I would argue that certainly on the substantive issue they lose because the city doesn't possess those rights. But I would argue as well that they do not have standing to press that issue. If the city, by the artifice of naming officials to sue in their official capacity, could get around this lack of equal protection or due process rights, then the substantive issue, which is that cities don't have those rights, would be meaningless. They could raise those issues anyway in every case simply by designating a city official to sue in their official capacity. So what they're really doing in their official capacity is attempting to assert equal protection and due process rights on behalf of the city, rights which the city, in fact, does not possess. And it would be a monumental change of the law where the city certainly granted those rights through this artifice.
The city does have standing to challenge delegation.
Exactly, Your Honor. And of course,
factors. And in this case, assuming the error is preserved, the issue that is raised by equal protection is largely subsumed within one or more of the bold legal factors.
it is, Your Honor, and that's the way that the city can get at the issue. But I want to point out very clearly that we disagree strongly that the Article 3, Section 1 issue is before this court. I'm looking at the Wilson case itself, and...
If the CA decided it, if it did,
Yes, sir.
you would have to complain about that here.
That's correct, Your Honor. If the Court of Appeals decided an Article 3, Section 1 issue...
And did it improperly, as you argue, because it wasn't raised or whatever, you would have to complain about that here.
That's right, Your Honor, but I want to point out that the Court of Appeals did not do that. I'm reading from their opinion. By point of error 5, the city asserts that because it is a home rule city, Article 11, Section 5, it possesses full powers of self-government not inconsistent with the Constitution and general laws. Then it contends that absent a specific constitutional provision, a home rule city cannot surrender or be compelled to surrender its governmental functions. That's the issue the Court of Appeals addressed, and that's the issue that the Court of Appeals decided. They specifically held that there was a delegation of the city's home governmental power that was in violation of Article 11, Section 5. They did not purport in any way, shape, or form to answer the Article 3, Section 1 question.
Well, in some way, shape, or form they did, because they went through boll weevil and concluded that the delegation doctrine didn't apply in this case. So,
what they argued in their decision was that the boll weevil case decided a similar question and therefore was applicable to the home rule question presented. That's what the court in Wilson said. So, and as we've argued, they misapplied that standard. But clearly, they were addressing the Article 11, Section 5 position. Now, I have gone through, in the petitioner's brief, beginning at page 16 on the merits, I have gone through the boll weevil analysis. And what I would contend about that analysis is that this court's decision in Proctor effectively disposes of the question even were the court to have reached that issue. This court's decision in Proctor v. Andrews went through each of the 8 factors. It found 7 of the 8 in favor of the delegation to the AAA and FMCS. Many of the standards that they utilized could be utilized equally and applicable to this case. So I would urge the court to go back through the analysis in Proctor. It is not correct to state that there is an inherent bias. In fact, in Proctor, this court touched on that very issue and concluded that the scheme set up by the statute does not provide inherently biased hearing examiners, but rather strikes an equal balance between the city and the police officer or firefighter, as the case may be.
if the statute provided that the officer could elect for his dispute to be decided by the head of his union or collective organization by whatever standards that fellow wanted to apply, would that be a delegation problem?
That would be a delegation problem, Your Honor. I think that if there was an Article 3, Section 1 challenge made, and as the court applied the boll weevil analysis, certainly there would be a conflict of interest issue that was presented. But this court looked at the conflict of interest portion of the boll weevil analysis in looking at the delegation to the AAA and FMCS and concluded that the statute in this case, the way it is drawn up, strikes an equal balance between the interests of the city on the one hand and the interests of the disciplined police officer or firefighter on the other hand.
I want to go back to the preservation issue for a moment. Is it your contention that the discussion on page 691 of the Court of Appeals opinion does not raise this issue because it does not specifically mention this or any other section of the Constitution?
Did you say on page 692, Your Honor?
691.
691. On 691, Your Honor, the court, in going through the boll weevil analysis, is purporting to apply that to the Article 11, Section 5 challenge made by the city. If you look back on page 690, they begin the discussion of the boll weevil analysis by noting that the city's point of error is lodged under Article 11, Section 5. Then they proceed, from noting the nature of the challenge as a home rule challenge, they proceed to apply boll weevil analysis to that challenge, and they conclude on page 692 by saying there is an overly broad delegation of governmental functions and police power, the city's police power under the home rule provision, to a private hearing examiner.
Also on page 690, it says the city urges that the statute is invalid and unconstitutional because it confers legislative authority on a private entity in contravention of Article 3, Section 1 of the Texas Constitution. We agree.
That's correct, Your Honor, and immediately below that they say specifically, the city asserts that Section 143.057 fails to provide any guidelines to the AAA or FMCS in determining whether examiners are qualified and neutral under the statute, and leads to the determination of such private entities on an ad hoc basis. This contention is similar to one of the arguments addressed by this court in Proctor. So their specific challenge under Article 3, Section 1 was to the delegation to the AAA and the FMCS, not the delegation to hearing examiners themselves.
One more question on a different issue. The city argues that the voters of the city adopted 1269M. And then 6 months later, the city passed an ordinance, which the city argues, in effect, supplanted the applicability of 1269M to the city. And they argue that as a result, neither 1269 nor its successors, its revisions, its recodifications are effective on the city. What's your response to that argument?
Your Honor, that argument simply doesn't fly. I mean, the logic of that argument suggests that a city, by passing an ordinance, can preempt higher state law. If the court looks at Section 143.002 and 143.004 of the statute, they say that the voters vote to adopt the Civil Service Act, the Firefighter and Police Officer Civil Service Act. The ordinance is simply the vehicle by which the city then complies with the voters' will. To say that once the voters have adopted the state statute and thus are governed by state law, that the city by ordinance could preempt higher state law would turn the law of the state on its head. The truth is that a city, under well-established case law, a city cannot, by local ordinance, preempt higher state law. Once the voters adopted the Civil Service Act, it was a state statute that applied to Lubbock just the same as any other state statute passed by the legislature. City of Sweetwater v. Guerin, and again cited with approval in Proctor, states that that preempted the field for firefighter and police officer discipline. And as Proctor itself held, it is well established that the state, by general law, can move into the area of a city's home rule authority. So clearly, the state law and not the ordinance governs.
Any other questions? Thank you, counsel.
Thank you.
That concludes the argument in the second cause. The court will now take another brief recess.